The original intent of the British North America Act was that the federal government was to be the supreme legislator across Canada. That is so that everyone would know the law right across the whole nation. The property under 9213 is to be what belongs to the province at the time of union. The civil rights under 9213 has absolutely zero to do with really your rights. It has to do with what referred to as the civil lists. The civil lists are what we used to pay to the Queen to pay for the running of her as a corporation and the civil servants. That's what property and civil rights are in the province. I have the proof. I would refer anyone who questions that to get the case of Mercer from 1881. It's at the Supreme Court of Canada. It was appealed back to the Privy Council, and it had to do with the royalty of, and I've been corrected on this, I used to say a sheet, but someone has told me I'm wrong, and it's a cheat. So anyways, a cheat is when someone dies. And if you don't have a will, get one. Because if there is no one before you that your estate can go back to, eventually it will do what's called revert back to the Crown. So the Crown will be a reversioner. That's what a cheat is. Thank you. So, but the only difference in the two rulings was that instead of the federal government getting that royalty, it was the provinces that got that royalty, and I think it's under Section 102 of the British North America Act. Mercer from 1881 from the Supreme Court of Canada has actually been cited in Canada for another reason. But it's still there. And it's a beautiful case. I think it's 208 pages long. Can you imagine reading that? Great case. But that is your real intent and interpretation of that act. Not only that, I have a document at home, and it is the true intent and interpretation of the British North America Act. And I have a manual on government from 1879 that spells it all out. That the provinces gave everything up to the federal government, and then they were divided into the 4 provinces that created the Dominion. And when they did that, they gave up their good government. These provincial governments are to be very small governments. They have the ability under Section 92(8) to create municipalities. In other words, they could create the legislation to create a municipality, which, by the way, is letters patent. Letters patent are a law. The letters patent dealing with your property deals with the honor of the Crown and the prerogative of the Crown. The prerogative of the Crown can never be given away. And the provinces have absolutely zero authority over the prerogative of the Crown. And the beauty thing is, there's this thing, and it's called statutory novation. And basically, their legislation has to honor the contract that is with the original patentee, his heirs and assigns forever. That's you guys. And so then this is where Section 109 of the British North America Act comes in. Subject to any trusts or any interests not of the province. So you do have private property rights in Ontario and in Canada. Now it's up to you folks to stand up for your private property rights. And that's why we have the Ontario Landowners Association. Good plug, eh? Yes, ma'am?
What is the title of your book?
The title of my book is going to be Property Rights 101, an Introduction. When the editor gets it done, then I'm thinking that I'm probably going to look at Tom Black, and Marlene Black, the editor and publisher of the Landowner magazine, to publish it, because the other publisher just isn't working out. So when it gets available, I'm sure we'll have an ad in the Landowner magazine, or anyways, it'll be okay. Yes, Albert?
Liz, I think it's important that people know about nuisance torts. When, as Jeff said about having property or in Moyer cases with the pallets, your neighbors can actually sue you with a nuisance tort. So you can't do things on your property.
Yeah. With private property rights, folks, you have what's called private property responsibilities. If you do not respect your neighbors, if you cause them any injury in any way, they can launch a tort against you. You can lose everything because they can sue you for everything. Now, this is actually happening with the wind turbines now. So if you're thinking about putting wind turbines on your property, you may want to double think that. There was a ruling came down for Clearview Township that the abutting neighbors of a property where the farmer is looking to put wind turbines on, as soon as any permits or any movement is made on that, the abutting properties can actually launch a tort and sue him. And so now the anti-wind turbine people are looking at this throughout the entire province. They brought that through. Actually, I was speaking at a conference. I was asked to speak with the panel on property rights at the University of Guelph. And the anti-wind turbine people had not heard this, and so I explained this.